momentum going and really contribute to the important collaboration in this area. But a lot has taken place between now and then, with the IRB having released its external audit on immigration detention in the middle of last year, as well as its management response and action plan. And so we're observing this marked effort by government to begin addressing in earnest the deficiencies in the system, which we'll hear more about just now. But despite these steps, the immigration detention regime in Canada continues at times to disregard implementing the most basic norms of procedural fairness and charter rights. In particular, Section 7, 9, and 12 of the Charter that apply to everyone in Canada and therefore should protect equally everyone against unjust, arbitrary, and cruel detentions. And during this time period as well, the immigration bar, advocates, researchers, civil society have continued to work together on a number of fronts to advocate for more significant improvements in the immigration detention system. And I hope this symposium gives you all a really good snapshot of all of these interconnected activities and also some thoughts and strategies about where to go from here. So without further delay, I want to begin our program with our first panel, and I'm very grateful to have my former colleague who I met in South Africa and worked with there for many years, and friend David Cote, moderate this panel. He'll give you more detailed information or introduction to the panel topic and to the panelists, but it's my pleasure to introduce him. David is currently a staff lawyer at the HIV and AIDS Law Clinic of Ontario. He's practiced immigration law in Toronto with a focus on immigration detention and refugee claims since 2017. Prior to that, he worked as a program manager for strategic litigation at Lawyers for Human Rights, a legal NGO in South Africa, and he's been involved with matters in all levels of South African courts, including cases involving immigration detention, international criminal law, extradition to face death penalty, and access to refugee services. In Canada, he's appeared before the Immigration and Refugee Board, the Federal Court, and the Superior Court of Ontario. Thank you, David. Take it away.
Thank you, Tal. We've seen many changes over the last couple of years in the sector, immigration detention sector. Many of these changes have been brought about by policy changes, but also through court interaction. The reactions to some of the deficiencies that we've seen in the system have been addressed by superior courts, and we've seen a use of the habeas corpus remedy more and more. This has culminated into a report that was issued last year reviewing the problems within the system and proposing changes that could see increases in access to procedural fairness within the immigration detention system. So today we've assembled a panel to discuss the immigration detention system in general, but really with a focus on the audit report that was issued in 2018. My first panelist to my left is Kathy Laird. So what we will be doing is introducing each of the panelists as they will speak. I do have handy signs regarding time limitations, and so I would ask the panelists to just glance over every so often. I will be using these. So I'd like to begin with our first panelist. Kathy Laird has extensive experience in the administrative justice sector, both internally as an adjudicator and mediator at several Ontario tribunals, and externally as a litigator and legal director at community legal clinics in Toronto and Northern Ontario. She has served as counsel to the chair of the Human Rights Tribunal of Ontario and as executive director of the Human Rights Legal Support Centre. Most recently, she was a member of the Social Justice Tribunals of Ontario until October 2018. For many years, Kathy trained new provincial adjudicators on bias-free adjudication, as well as on accessible decision writing, evidentiary issues, and the conduct of hearings. In 2004, in recognition of her work in Ontario's tribunal system, she received the Medal of the Society of Ontario Adjudicators and Regulators for outstanding contribution to administrative justice in Ontario.
Yeah, it's good.
Well, in 2017, if I may just introduce the report. In 2017, Kathy was retained by the chair of the Immigration and Refugee Board to conduct an audit of the immigration detention hearings across the country to determine if appropriate standards of procedural and substantive fairness were being met. Her report was issued in April 2018, and I'll turn it over to Kathy to tell us about it.
Thanks, David. I don't know if this is in the right place. Is everything good? Yeah, okay. Okay, so as you may be able to tell from the bio, I have never practiced immigration law. I think I did what was called a special inquiry in law school. So when the former chair, Mario Dion, approached me to do this, I was cautious about it. I think he was looking for a human rights lens and a different kind of adjudicative background. But when you get to be my age, you know what you don't know. And I approached the task with some trepidation. But having said that, once I started in on the review, it didn't take long to see what the problems were and to start sharing preliminary findings with the chair. As has been said, the task was to review the fairness of the process and also, without conducting any kind of judicial review type process, to make sure that the results matched the evidence that was introduced. And in particular, to juxtapose what I found with a series of judicial decisions from the Federal Court of Appeal, Ontario Court of Appeal, Alberta Court of Appeal, some decisions which you're familiar with, but some of you may have argued and are being discussed later today. So by way of overview, let me say that the audit reviewed 312 hearings for 20 different files, and that was 18 individuals because 2 people transferred between regions, so there were 2 separate files. We didn't choose the files, they were selected on a random basis. When I say we, there was someone else who did review the French language hearings. They were selected with a mix of regions, roughly representing the proportion that each region had. But all the cases, the person had been held for at least 4 months. I didn't use a lot of adjectives in the report, but I think it's fair to say here that I was kind of shocked by what I found when I listened to those hearings. I listened to about 275, that's a lot of hearings. Some were well under 5 minutes, some were longer. In the report, I used a lot of examples because I hoped that the examples spoke for themselves. And I found that everything that I found that was negative had been remarked upon by one court or another. So I was able to throw that in because I was always nervous about resistance within the tribunal and within the members. So knowing that I didn't have a background, it was important to be able to say, look, I'm not the only one finding these results. So what were the key things I found? I'll try to go through this quickly. So inconsistent and inaccurate factual findings. One example was a file where a person was held for 59 months, and most hearings said that there was a very dated record of serious criminal offenses. But every so often there would be a mention of a firearm or a weapons charge. It's really inconsistent. At the end of listening to every single one of those 59 hearings, I had no idea whether there ever had been a weapons conviction. So it seemed to me that if you're holding someone for 59 months on the basis of their danger to the public, you should know whether there's a weapons conviction or not. One adjudicator, one member added public danger as a ground after a year. And he didn't realize he was adding a new ground. There were no submissions about public danger from CBSA. He just added it. And then every hearing thereafter cited public danger. I think for me one of the saddest was a case where a young person had a legal aid lawyer for 2 hearings. And at one, they presented a plan for them to be released to their family. There was community counseling, but no drug counseling. And that plan was rejected because there was no drug counseling and because the young person would be too close to his family and in an urban setting, the same urban setting. So then the same lawyer comes back 2 months later and has a new release plan in a rural setting with a facility that has drug counseling and other counseling, and he has the director of that facility on the phone. He arranges for there to be a telephone in the hearing room. And the adjudicator, the member, won't allow that director of the facility to testify, to give any evidence. And this adjudicator finds there's no need for drug counseling, so it's just like, why did you get a facility for drug counseling? He doesn't need that, which is true. He didn't need it. The first adjudicator had made a mistake. That release plan is turned down because it's a rural setting. He might be able to walk away, and he's too far from family. So I don't think the second adjudicator had any idea that he was contradicting all the findings of the hearing 2 months later. But that was the last time that young man had a lawyer. It was many months after that, probably 2 years after that, that he was held. So he never got released. So he never had a chance to show that he had improved. And he was deported to a very dangerous country where he hadn't lived since he was a child, and he didn't speak the language, and he had no family. I mean, he's probably not even alive now. I guess that's now I'm perhaps going too far, but you know those were sad cases. And you know, a big issue was that there weren't, especially in Central Region, most of the problems were in Central Region and in Ontario. In Ontario, because there was far less legal representation. Eastern Region does go into Eastern Ontario, but across Ontario there's a problem with representation. And then in Central Region, there weren't decisions in the file, so it wasn't easy for an adjudicator to find out what happened at previous hearings. Sometimes they'd rely on their own decision from, you know, a couple of years before, because they were familiar with that, but they didn't really know what happened in the interim. The thing about oral decisions is they just can kind of disappear, unless there's counsel, and the first thing every counsel did, I saw in the file, was ask for all the decisions. We looked at the paper files in addition to listening to the hearings. So then other things were uncritical reliance on CBSA statements, failure to question CBSA on delays. So in one instance, CBSA says, we sent away fingerprints to Interpol a few months ago, but in fact the fingerprints had been sent away 2 years ago. But so the member found that they were being diligent, but they didn't know that in fact that was misleading. And I'm not even saying that necessarily CBSA was intentionally misleading. They were switching officers as well, so you know, I don't think that they were likely intentionally lying. Sometimes you would see that a CBSA officer would stay with the case and would have an incredible tunnel vision. I definitely saw that. So it was hard to say, would it be better if you always had the same CBSA officer, because some CBSA officers really seem to not be able to take on an officer report role and seem to be quite vehement in their opinions about whether or not someone could possibly be telling the truth. Okay, so also a failure to actively seek and hear the relevant evidence. I've already mentioned that one example of the facility director on the phone. The worst thing, and it had stopped, I think, by the time I started the report, but it occurred in all the decisions I reviewed, was the failure to allow a bondsperson to testify. Because that stopped, I don't think I'm going to go on about that, but it definitely was. It had, well, I see some people shaking their heads, so they can speak to that in the question. But yeah, that was, because what would happen is the CBSA officer would interview the bondsperson in the hall and then come in and say what they'd said. So sometimes the person detained would object to that and say, how do I know that that's really what they said? And sometimes the members would say, I can't approve this release because I don't know if this bondsperson really understands the history, really has a mortgage, really has the ability. And it was like, well, you just have to, they're in the hall. You can just bring them in and answer those questions. So that was quite incredible to me. But I understand that CBSA stopped doing that too, that they wanted them in the hearing room on account of a federal court decision that cut the other way. But yeah, I'll hear from you. Okay, so, and I guess something else is just the feeling that the members were communicating, this is your hearing, like you're the one that's being detained, and I want to hear from you. It it's important that you understand what's going on and tell me what you think. Some things were not that accessible to people. Like people would talk about how their grown-up children, you know, had room for them in their house and their granddaughter was sick and they just wanted to get out with their family, and that would count against them. In every single case that I heard where family and community ties were an issue, it counted against them. And that is kind of counterintuitive. The idea was, you know, I guess that you had a motivation for going underground, but it seemed to me kind of self-evident that in the cases I listened to, these particular people really didn't have the wherewithal, resources, or the will to go underground. I'm running out of time. Oh my God. Okay, so I think I'll just probably stop there. I kind of touched on the main things I wanted to say, and I guess some questions.
We had some questions prepared. One of the things you mentioned was that the member could have asked and whatnot. And one of the things you mentioned in the report was about active adjudication. And the active adjudication model could be one way to remedy some of the deficiencies. Can you explain a little bit about what active adjudication means?
Okay, well, active adjudication, to do it well, you have to really care about the results. So that's the first thing. You have to be engaged with the process. And it's not enough to be engaged with the particular hearing in front of you in the case of these hearings. You have to care about the long-term result for the person, because this is pretty unique, right? These series of hearings that go on and on. So you're engaged in the process, and then you are actively seeking the relevant evidence. And that mean you know, making sure that you explain everything. Like, for example, you can explain that close family ties, that the CPSA thinks that close family ties means you're going to go underground, and you can say, I want you to tell me, is there a risk that you'll go underground because you have family here? You see, then the person can actually speak to that, and they would, they could address it fairly, but they didn't understand what was going on. So that would be one example. The same with having made a Prague claim or a refugee claim. That usually counted against them too. And I can see why that would sometimes be appropriate, but the person needs a chance to address that. Then with CPSA, of course, it would mean much more close examination of the statements that are being made, considering when you actually need evidence. Sometimes the investigation officer needed to be called and wasn't called. Sometimes the hearing officer should have been giving affirmed evidence. That was the other thing, that in Central Region, uniquely, detainees weren't given the opportunity to give sworn or affirmed evidence. So it kind of meant that everything they were saying was just, it kind of disappeared. Like, very seldom was it in the decisions with an assessment of the credibility of any statements that they've made. I mean, people did get upset at these hearings. Okay, I gotta stop. I guess the other thing is that you have to wrestle with the burden of proof. So it seemed to be that if there was just a risk that a person might commit another petty criminal offense, then that was enough to detain them. But it's not about a risk. It's about a greater than 50% risk. So that was completely absent in the analysis, and would also, be part of active adjudication. That, if you're going to make that kind of a nuanced assessment, you have to engage with the evidence with much more attention to detail. Okay, I think that's it for active adjudication.
Were there any specific recommendations that you made in the report for improving the system?
Yes. Okay, so there were some kind of specific and I hope pragmatic suggestions, and many of these may have, some steps may be taken already in this regard. One that I know was an, are you having trouble hearing? Yeah, sorry, I guess I'm moving away. So one was, is that good?
Yeah, that's
Yeah.
perfect.
So an immediate review of all the files where people have been held for more than 6 months, and I think that was done. Transcribing all decisions, so it's easy for the adjudicator, but also the manager to tell what's going down. Full transcripts of key hearings, at least that. So I guess the 7-day, the 48/7, and all where there's a release plan. New internal protocols on opening statements, affirming evidence. Some of these things that I thought could help were things like practice directions and interpretation guidelines, which I've seen in other tribunals, but perhaps in this context it would be the new guideline that I know that the tribunal has been working on. But these things need to be public and need to go to consultation, and sometimes they could be things like the right to cross-examine, be able to evidence, those things are kind of obvious, but also some tribunals have used something like the family ties. When is it a positive thing? When is it a negative thing? You could have an interpretation guideline on that that would set out the different decisions and alert parties that what they should be addressing, so that there was a better chance of getting a more nuanced consideration. I thought that Central Region should talk to LAO and see if they could get, because the other provinces do have much better representation. More fundamentally, I thought that the detention, what do I say, detention, the ID, I'll just say the ID. Division, it's a division. We have the federal lingo, the provincial lingo. Realignment was a statutory mandate, which is, after all, the default position is to release. I thought that was important. Make sure they put the burden of proof on CBSA, because it seemed to be slipping over to the detained person. Some of the issues that I've already mentioned, active adjudication, increased oversight of the files, sort of shifting the adjudicated culture from what members treated hearings as one-offs, and the file would just be kicked from one member to the other. And so that the tribunal taking overall responsibility for the experience of the person in the system. So that I thought panel meetings that other tribunals have a role here, so that the different adjudicators that have handled a file can talk about, can meet and say, okay, this person's been held for a year and a half. What would a good release plan look like for this person? Like, what are we missing here? Because the goal isn't to just have these things roll on forever. You're supposed to be releasing if there's a way to release. So some of those things that I saw at other tribunals. I also, recruitment, I thought there needed to be a different balance in the members. There are a lot of CBSA, former CBSA staff who are members, and I saw some good decisions from former CBSA staff, particularly in Western Region. But just like the OLRB recruits from management side and labor side, the courts, Crown Counsel, Defense Counsel, you need to have people who have represented immigrants and the people who are held in detention. And I think that with Aviva, we have seen a step in that direction for sure. Okay. It's all right. And then, I thought there was room for training. There had been quite a lot of training, and Nancy may speak to that later. Sometimes it just didn't seem to take, especially in Central Region. So I thought that that could be incorporated into more panel meetings and discussion of the guideline, a whole different sense of a collaboration, a coherent approach to files. That might help. And I really felt that there was a weird thing about credibility assessments. You saw that in a case like Ali, where the court could easily find that there was even though the person had abuse, substance use, and there were memory lapses and a messy life, there still was a coherent story that ran through it. And the court had no problem finding that. The court saw that if someone came up with a fake birth certificate to get deported and was successfully deported to that country only to be held in jail and brought back, that was an indication that they would do anything they could to get out of jail, to get out of detention. Not an indication that they were just a hopelessly dishonest person that was lying all over the place. So I found that troubling. Why are these credibility assessments so out of touch? A good adjudicator has to be able to see things from the point of view of the person on the other side. You do have to be able to see how their story from their point of view might pull together, because they don't have your life. So I'm not sure how you exactly address that in training, but that did seem to me to be a big deal. Okay, I think I'll stop there.
Thank you. I'm sure we'll have questions from the audience afterwards as well, so we'll be able to address all of those. But thank you very much for that presentation. Our next panelist is Aviva Bassman. Aviva is the Assistant Deputy Chairperson of the Immigration Refugee Board of Canada in the Immigration Division. Before that, she was most recently a Senior Legal Officer at the UNHCR Canada, and previously a staff lawyer for over 8 years at the Refugee Law Office. She also formerly served as counsel for the Department of Justice. Aviva has a JD from Osgoode Hall Law School, and welcome to your presentation.
Thank you. JD would make me younger than I am, but thank you. When I read Kathy's audit last summer, I had mixed reactions. I was, of course, as I'm sure everyone in this room who's read the audit was, deeply concerned, upset by the examples that were listed in there. I was also unsurprised. When I was a lawyer, I was representing detainees often, and many detention reviews were marked by serious gaps in procedural fairness. And maybe that's why I was also pleased. So why would I be pleased? I was pleased to see the issues explained in such a frank and clear manner. I was glad that the audit, which had been commissioned by the IRB chairperson in 2017, was made public. The IRB's transparent acknowledgement of the issues in its management response and action plan was, for me, a key step in what I would come to understand was an ambitious plan to reform the adjudicative culture at the division. My first inkling that the IRB was serious about making a culture shift actually came before the audit was released, when I had a chance to meet the then new deputy chairperson of the Immigration Division, Roulette Litrides, in the spring of 2018. If any of you have met her, then you will likely share my impression. She is down to earth, she's intelligent, and she is deeply and genuinely passionate when she speaks about liberty interests and fundamental justice. I became convinced that under her leadership, supported by the new chair, there was a crucial moment happening at the Immigration Division. I understood over the next half of a year that the board was committed to a culture shift within the division and was committed to ensuring that detention review hearings are fair and robust, and that the rule of law and the Constitution should govern process and outcome. Given that administrative detention for immigration enforcement is an extraordinary liberty restraint, members have an immense responsibility and power. And while recognizing that members make thousands of well-reasoned decisions every year, often in challenging circumstances, the gravity of detention decisions require the IRB to be proactive in identifying and pursuing opportunities for improvement. And so in addition to the culture shift that began at the management level and that was recommended by Ms. Laird in her audit, other important progress has been made, and I'll touch on a few of those before I turn the mic over to my colleague, Nancy. First, in terms of long-term detention, the main subject of the audit, for a period of time, all cases that were more than 6 months long, where people were detained for more than 6 months, were actually transferred to other regions, and so other adjudicators took their fresh eyes to the case. Cases are now back in their home region, but there are reports being provided after every single long-term detention case to the deputy chair and to the assistant deputy chair. In terms of procedural changes, In addition to what Ms. Laird already noted, bondspersons are examined now by members directly. There has also been a change to case assignments, so every case that is 30 days or more is assigned to a member. There's exception for Maplehurst only because of the logistical complications of adjudicating at that facility, but those cases are triaged, and cases that need to be assigned are assigned based on factors such as case complexity, voluminous materials, identified vulnerabilities, etc. There are, of course, extenuating circumstances where members have to take cases on at the last minute, when there's a member ill and they're trying to balance their obligation and the person's right to have a detention review that day, when there's counsel present, bondspeople present, and members I have found since I started working at the division 4 months ago are very professional in their response to changing circumstances and the challenging conditions in which they adjudicate. We are also committed to quality assurance with regular reviews of transcripts and decisions and feedback to members, and we're also exploring other ways to make sure that we complement our own management's ability and legal team's ability to do quality assurance, even if that means contracting out with experts some of that work so that they can complement the work that we're doing. In terms of staffing and recruitment, the most recent recruitment of members focused exactly on what Ms. Laird recommended, to bring diversity of previous experience to the member complement. We have a new cohort starting in a few weeks, fingers crossed. I'm just waiting for some paperwork to come through, and so I can't announce their names yet, unfortunately, but I'm excited. I will be excited to when I can. They're all lawyers. They've had previous experience in immigration, refugee, and or detention work in the private bar, and I think they're going to contribute to this culture shift in a really, really important way. The deputy chair is also chairing designated representatives working group, given the very serious concerns that were highlighted in the report regarding detention of persons with mental health issues. They're overhauling the program, and that is going to be going out to stakeholders for consultation. And we're also working with CBSA to see whether designated representatives can be appointed earlier in the process. There's also, before I joined, there was also a program with the Refugee Law Office to refer cases of persons with mental health issues who didn't have representation to legal aid. Speaking of legal aid, I agree. It is one of the biggest gaps in the ability to ensure a fair hearing in the Central Region. The absence of a duty counsel program is, I think it has a huge impact, frankly. And we are speaking with Legal Aid Ontario, and I'm hopeful that they will be able to either pilot a program or put in place a program, and if they aren't able to, for whatever reason, then we will look at other options, because it's like, of the few things that I would consider the most important for ensuring fair hearings, the legal representation is high up there for me. The detention guidelines, which everyone has been waiting for quite a long time. I keep looking at my phone to see whether there is like exciting news, but there's sort of exciting news. I just can't say that it's public right this second. But it's been signed off on by the chair, and it will be made public today or Monday, I believe. Now, every time I say it's imminent, I've been wrong, but I'm very hopeful that this time my intel is good. There were extensive consultations on the guidelines. Some of the people in this room provided helpful, thoughtful feedback. We appreciated that. You will see your feedback, I hope, in the guidelines. In the fall, there will be further stakeholder consultation in order to see how the guidelines are working in practice. So there will be an opportunity to further refine the guidelines. It's entirely possible that there are things in there that have an impact that weren't intended, and so it will be an ongoing process. Many of the issues raised in the audit are addressed in the guideline, including the overall need for active and compassionate adjudication, guidance on alternatives to detention, treatment of issues affecting minors and vulnerable persons, evidence and disclosure expectations, There is a much greater emphasis on charter consideration, and Nancy will be taking you through some of that in detail, even though we don't have copies for you today. She'll talk about it a little bit more in detail. On professional development, I'm looking forward to a dynamic and in-depth series of professional development sessions using outside speakers and experts on a range of topics that are also in the guidelines, again, from the Charter and international law to evidence to credibility. Right now I'm speaking with a bunch of academics about how to put that credibility session together. Compassionate adjudication, best interest of the child, and further training on mental health issues. We've increased training to twice a month. And also, in order to bring about national consistency, there are several national trainings per year. We had a 3-day session in January where there was a focus on, again, active adjudication, mental health issues, and even bias and assumptions. Deep and sustained change takes time and commitment. I'm both impressed with how some of the things are coming together, and also share the impatience that some of you in this room no doubt feel. I am every day aware that we're talking about fundamental liberty interests, the right to a fair and meaningful consideration of each case. It can't happen fast enough for me, but unfortunately, or naturally, these things take time. It takes time for patterns to change and for training to take hold. If you have concerns, for the lawyers in the room, if you have concerns about a member's conduct of a case, there are ways to make complaints. You can do that formally through the Office of Integrity at the IRB, or you can raise them informally with me or with the deputy chairperson. And also feel free to keep sharing your positive feedback. I have heard from some of you that the tone of detention reviews is changing, that there's a noticeable shift. We are not there yet. There are still important gaps that we need to address, and we are working on those. I don't know if you want to ask questions now, or if you want to first turn it over to Nancy.
Sure.
Okay.
So we can turn it over to Nancy Weissman. Nancy is Senior Counsel in Legal Services at the Immigration and Refugee Board of Canada. She is a graduate of Osgoode Hall Law School and is a member of the Law Society of Ontario. She has lectured extensively on issues pertaining to immigration and refugee law at various legal conferences throughout Canada, and has published in the International Journal of Refugee Law and McGill Queen's University Press. Nancy, thank you.
Thank you very much. Very happy to be here. As Aviva mentioned, our big news is that Rula Atreides, the Deputy Chair, has confirmed with us last night, this morning, that the guideline is final. The guideline will be released either today or Monday, and we feel fairly confident that that will be the case. So while, as Aviva said, we don't have a copy to share with you, what I'd like to do is to have gone through it extensively and, of course, and to share with you some of the key features of the guideline that I think not only directly address many of the concerns in the audit that Kathy Laird expressed, but also many of the stakeholder comments. Rula Atreides, the Deputy Chair, had extensive consultations with the stakeholders, and I think that you will hear that many of the stakeholders' concerns and suggestions have been incorporated into this guideline, and they're quite extensive. So, of course, I'm not going to go through absolutely everything, but there are some key points that I want to mention to you, and in certain instances I'll actually read out what the guideline says. So the guideline there's obviously various sections, and here are some of the key features of the guideline. Obviously, it's noted as the policy on the use of chairperson's guidelines, and it's right at the beginning under objective and principles, and there's some very interesting things in the first section that, although chairperson's guidelines, as you know, are not binding, members are expected to follow them, and that's at the very beginning of the guideline. And basically, unless compelling and exceptional reasons exist, they shouldn't be departed departing from them. If they do, they have to indicate in their reasons why they're not following the guidelines. So the first thing I want to point out in the first section, and I'll mention some of the sections for some of the key ones, 1.1.6, the guideline says the onus is always on the minister. And the onus and the evidentiary burden remains on the minister at every detention review. And obviously that directly relates to some of the confusion in the case law. Perhaps that maybe that isn't the case, or that perhaps there is a shifting burden away from the minister, but the guideline is quite clear, and this is of course guidance to members in the conduct of their detention reviews and their assessments. Another very key aspect of the guideline, which really is throughout the guideline, but it's stated in a few key sections, and that is 1.1.9, all detention and release decisions must be made with charter considerations in mind, in particular sections 7, 9, and 12. And that the charter requires, of course, a robust review, and that the analysis and conduct is to be reasonable, necessary, and proportionate based on the particular circumstances. So again, this emphasis on charter considerations, because of course we're talking about liberty interests. Another key aspect, and this is throughout the guideline, is the notion of, obviously ID members can impose conditions upon release. But the guideline indicates that conditions of release are not always required. In other words, a person can be released depending on the circumstances without specific conditions. But where they are, it's important that they are, and I'm quoting, they should be tailored to the particular circumstances of the individual, given that they are restrictions on liberty. Another aspect of the guideline, I think that mentioned by Kathy Laird in the audit, is the nature of detention reviews and this notion of compassionate adjudication. And there is quite a lot, and I will be mentioning other aspects where there is very definitive sections that, while maybe they don't mention the topic compassionate adjudication, definitely are informed by those concepts. But one aspect as well is a mention with respect to the code of conduct for members of the IRB, and that hearings are to be conducted in a courteous and respectful manner while ensuring that the proceedings are fair. So I'm going to skip a lot because the guideline goes through the various grounds and then goes into conditions of release and active adjudication, which is really what I want to focus on. One aspect under danger is that members have to consider the circumstances that led to the original determination of danger, and where in circumstances where the underlying cause of danger to the public or that finding was in relation to certain vulnerabilities, that members have to take that into account, that perhaps the vulnerability due to addiction or mental health, and whether those vulnerabilities have been mitigated. So if it's in relation to mental health or drug addiction, has that been mitigated, and therefore the danger to the public has been mitigated. One thing that Kathy Laird mentioned in the audit is under flight risk, one of the factors in the regulations states or mentions about the existence of strong community family ties in Canada. And it doesn't mention in the regulation, of course, how that's to be interpreted. And I believe she mentioned that in many instances it was interpreted in a negative light. The guideline at 2.3.4 actually says factors to be considered, such as previous compliance or non-compliance, or the lack or existence of strong community family ties in Canada, should not automatically lead to a conclusion that a person concerned is unlikely to appear. has to be considered in the context of the specific case, and not only that, that the concerns have to be articulated to the person concerned. And this notion of articulating to the person concerned is really a theme throughout the guideline, this guideline, because whenever a member has concern about anything, whether it has to do with particular conditions, a bonds person that's proposed, even a joint recommendation where the member has more questions about it, is that if there is an impediment to ordering release prior to a member making a decision, the guideline focuses on the notion that the member should articulate to the person concerned, if counsel is present, to mention to counsel and say, this is what I'm concerned about, and so that either it is addressed right then and there, or it can be addressed for the next detention review. A very large section has to do, of course, with release and alternatives to detention. So again, this notion under 3.1.2 that release without conditions should be the first consideration. And I think that is something that may not have been stressed in the past, but certainly this is a key consideration in the new guideline. And also that with respect to release, the principles of proportionality and attainability must apply to every interference with deprivation of liberty, and the guideline says each condition imposed is a restriction on a person's liberty. So the notion that not just detention, but any condition is a restriction on their absolute liberty, and those things have to be considered. Sort of like in the Antage decision, this latter principle of imposing restrictions as little as possible geared to the circumstances. Another aspect is that sometimes bonds persons are put forward and they may be rejected, and they may be rejected early on in the process, perhaps the 48-hour, the 7-day review. So 3.1.3 says members must actively consider and reassess alternatives to detention. And this may include reassessing alternatives to detention that have previously been considered. And that would include bonds persons who had previously been considered and perhaps rejected. And that may be, depending on length of detention or just depending on other circumstances, members should be revisiting that. Another key concept is this notion of if a member is going to be indicating in their reasons with respect to anything that has been put forward at the detention review, that they have to articulate any concerns with a proposed alternative to detention. Another aspect is with respect to, I think, a compassionate adjudication, that there's a heightened obligation to consider alternatives to detention for vulnerable persons. With respect to, and there's an example of mental illness, minors, the elderly, individuals with diverse SOGI, and so on and so forth. I think that's very interesting is the use of the term vulnerable persons. Because as you know, the Vulnerable Persons Guideline, Guideline 8, focuses mostly on procedural accommodation. The guideline looks at and talks about in a few sections vulnerable persons more towards substantive assessment and not just procedural accommodation, and I think that's very important. Another important aspect are joint submissions for release. Sometimes there's a joint submission between counsel and the minister. Members are to normally would endorse it, and in an exceptional case that they don't, at the time they should give the parties notice of their concerns so that there's an opportunity for counsel and the minister to confer to possibly come up with a different joint submission. With respect to bonds persons, if the section starts with if a member determines that a bonds person is necessary to motivate compliance. And I think that's pretty significant because rather than just assuming that in every single case in order for a person to be released, that there must be a bonds person, the wording is if a member determines a bonds person is necessary, which means that a bonds person isn't always necessary in the circumstances. That a bonds person, if they're available to testify, they should be heard from unless there's going to be a joint recommendation for release, and then they don't necessarily have to. Another important aspect is the notion in Thanavalasingam that if a member is going to depart from previous reasons, the wording now says members must articulate their reasons to depart from past decisions regarding previously considered bondspersons. So rather than them having to have to have what was known in Thanavalasingam as clear and compelling reasons, not stating anything with respect to that decision, but the guideline says members just have to articulate why they are going to depart. A very key aspect of the guideline, and I think you're going to be very interested to hear this, is with respect to minors, all minors, not just minors in detention. So 4.1.1 says this, and I think it's important enough just to read this important section. Pursuant to the requirements of the Convention on the Rights of the Child, members must take into account the best interests of any child, whether detained under the IRPA or not, and whether housed with a parent or not, as a key consideration in any detention-related decision of a parent or guardian. Now, the guideline does say that where a child is neither detained or housed, that this should be raised with the division. So obviously, if it's a circumstance where a parent or guardian is detained who has children at home who are not detained, that it's important to raise that with the division so that the member is aware that there are children at home. And then the section talks about and lists a number of factors of what should be considered with best interests of the child. And it's very similar to the list in the proposal and in the national directive in terms of the best interests of the child. So again, the best interests of a directly affected child who is a minor, who is under 18 years of age, must be considered before making a decision on detention of the minor or their parent or guardian. And I think that's quite significant. Again, in terms of vulnerable persons and the notion of compassionate adjudication for persons who have certain vulnerabilities, and there is a reference to the guideline, such as mental illness, members have to take into effect that may affect their ability to comply with conditions of release and whether a less restrictive alternative should be considered. And again, that's very significant because the vulnerable persons guidelines are mostly procedural in nature. This goes more to substantive decision making, and I think that's very important. With respect to designated reps, and I'll just probably come close to finishing at that point. This point is that members have to question the designated rep with respect to what steps they've taken to assess the person. So there's an active requirement to do that, and I think that leads to the last thing second last thing that I want to mention is this notion of active adjudication. 7.3.7 says the member should play an active role in ensuring they have a sufficient evidentiary record. Active questioning to fill gaps. Give concerns to the person in plain language. Testing the minister's representations through active and probing questions. So I think it's a direction to members that they have to play an active role in the detention review. And I'll end on one point, and that is 7.3.4 has to do with ministerial disclosure. And of course, this was one of the main points, I think, discussed in Brown. But I think that, I'm going to read what it says. The minister is expected to disclose all relevant evidence, whether or not it is exculpatory or they intend to rely on it. I think that's really significant. I think that the case law has been leading to that. I think a very recent decision, for those of you who are familiar with the Allen decision, I think that it's quite clear that that's what the court was saying. We have many, many other cases, I think, before the RPD where clearly The requirement on the minister to disclose is what's ever relevant in the file, anything relevant to the detention review, and I think that's very significant. So I'm going to end there, and we'll take questions.
Thank you very much. I'm very keen on allowing the audience to ask questions as well, so I think we'll move on to our next presentation. Sarah Boyd has been working for almost 15 years with refugee claimants and in the area of immigration, refugee, and national security law since 2009. She practices at every level of the immigration and refugee system. Excuse me. She is an associate at Jackman, Lazemi and Associates, where she works with some of the most knowledgeable and experienced counsel in the field. Sarah, I'd like to hear your perspectives on the system, please.
Okay, so I had the benefit of being involved in 4 out of the 5 security certificate cases, the IRPA security certificate cases, and so that's given me a somewhat different perspective on what detention matters would look like if they were actually being adjudicated in the federal court, which included some things that should be taken from that process and other things that are problems that crop up regardless of whether you're in the federal court or before the Immigration Division. But I am very heartened by what I have seen and what I've heard in the last couple of months. Even at my office, we've had some surprising experiences in front of the Immigration Division. So while it's very important for us to keep the momentum up, and for everyone to hold everyone else accountable, I think that we might really be looking at the kind of reform that the system needs.
Sarah, could you maybe paint a clear picture of what a procedurally fair detention hearing would be like, and what difficulties continue to exist in your experience in these hearings?
Okay, well, as sort of a basic overview, a procedurally fair hearing in a detention review would look like a procedurally fair hearing anywhere else, which is to say that 2 parties would be coming to the table with the same information, and they would be treated the same way by the tribunal, and that would not that wouldn't be something that would be hidden. They would both sides be able to see and be confident that they were being treated the same way. The focus of everyone, the hearings officer, the Immigration Division member, and counsel should all be on restoring the detainee's liberty to the greatest extent possible. And there are a number of things, and I would say perhaps a large number of little things that add up to the current process generally not being fair. It sounds like a lot of those have been addressed or will be addressed in the guidelines. So hopefully I'm not sort of preaching to the choir here. But sort of overall, what's currently unfair, some of the sort of top issues are, for people arrested unexpectedly, 48 hours is often not enough to retain counsel and put together a release plan. That's frequently a problem. CBSA, even if they're required to make disclosure, that's great, but it gets handed to you when you sit down in your chair at the hearing room. That's not acceptable, especially because sometimes this has happened recently to me. It contains something that if I'd known about, I could have adjusted the release plan we were presenting and done a joint release plan, but I didn't get it until I sat down. There continues to be an obvious close relationship between CBSA and the Immigration Division, and the sort of clearest sign of that to me and to clients, and something that I don't know if the Immigration Division and the CBSA officers even see, is that when you walk into a hearing room or when the detainee is brought into the hearing room, the CBSA officer is already there, sitting, sometimes chatting with the member. And it really presents the appearance that the CBSA and the member are a team, and you are the outsider. and it destroys the confidence of the detainee that they're going to get a fair hearing. And it is as bad as it is at the Toronto Immigration Holding Centre, where I do the detention reviews I usually do are there. It is so much worse when you're at, say, Maplehurst, where the member and the CBSA officer get to waltz in first together with their suitcases and their cell phones and their laptops, and just sort of sashay in and get settled in the room. And then counsel has to stand there taking staples out of their paperwork because they're not allowed to bring in a staple. It's such a, we're being treated so obviously as second-class citizens, second-class representatives. And in fact, during some litigation that was happening in Ontario court, myself and an articling student from my office were going into Maplehurst to speak to some detainees, and we had a court order allowing us to do this and to tour the facilities. And we were allowed to go in before the Immigration Division members and the CBSA hearings officers, who became loudly and actively upset with us. How dare you, you're just counsel. And unfortunately, that's not unusual. Not to say that every member has that attitude, but if I walk into the room and you're chatting about your weekend with the CBSA hearings officer, that is what it looks like to me. And in terms of an apprehension of bias, it's huge. Rexdale is a disaster. It's remote. A vending machine would be so amazing. Not having shotgun scheduling would be so amazing, but some of these things can't be fixed. But the fact is that I'm sitting in the waiting area for 6 hours, and the CBSA counsel is in there chatting about their weekend to the member. That is not right. I don't think Rexdale needs to be anywhere near as securitized as it is, but if I have to walk back and forth and get the key from the locker and sign in and sign out at 3 different doors, sign in at the front desk, sign in at the second desk, sign in when I go into the hearing room, then CBSA should have to do that every time they go in and out the same way I do. I don't think anyone should have to, but if I have to, CBSA has to. It just appears so terrible. And I don't think that anyone on the side of the Immigration Division or even on the side of the CBSA knows how much it looks like they're a team and it's us against them. Another issue that has come up, it doesn't come up in every case, but it does seem to come up in a lot of mine, is that the Immigration Division is not the final arbiter of release. I expect they think they are, and I'm pretty sure that IRPA and the regs say they are. But the fact is, if you have an order, you have to take it over to yet another window, and then a mysterious CBSA officer you never meet gives it the final say-so, yes or no. And they can reject an order from the Immigration Division. No, we want the bond to be higher. We're only going to release it if you agree to a higher bond. Or, no, we don't think that bondsperson can be an acceptable bondsperson. At the end of every Immigration Division hearing, when an order has been given, the member says, say it was your 48-hour hearing, the member says, if for some reason you haven't been released, we'll be back here in 7 days on such and such a date. That's not enough. The Immigration Division member who released should either remain seized until the person is released, and when I say seized, I mean in the building until the person is released, or there needs to be an on-duty member, because the law says it's the Immigration Division that orders release. It would be different if there was something that counsel had misrepresented or withheld that CBSA finds out about after the fact, but when you have put forward all of a bondsperson's financial documents and a sworn affidavit, and they've testified, and the CBSA hearings officer in the room with you has agreed and put forward a joint submission on release, and then someone you never meet, never see bounces the person, and they stay in detention, forcing the family to decide, do we wait another 7 days? Or do we try to come up with the extra money? That's ridiculous. And I don't know how common it is, but the fact that it happens at all is a major flaw in the system. And anytime it's happened and we've tried to go back to the Immigration Division, they've said, well, there's nothing we can do for you, the member's gone for the day. So I don't know who that mysterious person is, but we need to find them. And the Immigration Division needs to take jurisdiction over final release. So I think a fair system would be one where CVSA was held accountable. That certainly sounds like, in terms of disclosure and in terms of its submissions, it certainly sounds like something the Immigration Division's new guidelines are going to address. It would be wonderful if, CVSA itself had come to the table here, but it hasn't. I think that there need to be improvements in expectations and access. Again, this is something it sounds like the guidelines are going to address, but rather than forcing detainees and their counsel to sort of guess at what a reasonable release plan would be and run it up the flagpole and see who salutes, it would be great if there was some public information about very generally, what kinds of things do you want to see? What kinds of, if a person's income is X, what kind of bond do you want? Give us a starting place. And that's really already been addressed, that when there's a problem with the release plan, the member really needs to say what the problem is so that it can be addressed in a new submission. And the Immigration Division, and again, I'm very hopeful that this is happening. The members really need to focus on the job of releasing prisoners. That's their job. Their job is not to detain or release. Their job is to release unless it's impossible. And unfortunately, a lot of the members seem to forget this and use giving reasons as a chance to go on a lengthy diatribe about how terrible the detainee is. That's unnecessary and it's unhelpful. And again, it wipes any chance the council has of convincing the detainee that their next hearing is going to be fair. So I think a lot of these things are being addressed. I think there are things that we as the bar need to help the Immigration Division address. So like I said, I think we really are moving towards a fairer process, but at the moment, and like I said, I've had some surprising good experiences at the I won't say good, surprisingly good experiences at the Immigration Division lately. So it looks like these things really are sinking in, but we can't get complacent, and we absolutely must keep pushing for a fair procedure, and for people to only be detained where it is absolutely necessary, and to have the minimum required conditions placed on them.
Thank you very much, Sarah. Appreciate your comments. We'll move on to our last panelist. So again, very keen that I want to give everybody an opportunity to ask questions. Hannah Gross is an immigration refugee lawyer and lead advocate in immigration detention with the International Human Rights Program here at the University of Toronto. She has co-authored 3 major reports on the impact of immigration detention on children and individuals living with mental health issues. She's worked on a variety of other human rights issues around the world, and it's currently finalizing a joint report on a response to the audit in the immigration detention system. Hannah, would you like to give us your comments, please?
First of all, thank you for having me here, and thank you for the organizers for putting together this fantastic event. And thank you all for being here on a Friday morning and participating in these important discussions. I wanted to start today by acknowledging the people who are at the heart of many of these conversations, but rarely have an opportunity to meaningfully participate in them. These are behind me photos of immigration detainees whose lives were deeply impacted and in some cases ended as a result of their experiences in the immigration detention system. In the middle photo, you can see a letter that one immigration detainee wrote to her family while she was in jail. And I think it's important to keep in mind these stories and lived experiences in order to appreciate the texture of human rights violations. It's important to truly, it's hard to understand injustices and empathize from a distance. And in order to arrive at viable solutions to systemic problems, it's helpful to anchor our analysis in stories and lived experiences. So with that said, what I'd like to discuss today is the next chapter in our advocacy efforts to bring about some of these viable solutions. But first, I thought I'd give you a bit of a bigger picture perspective. I know we've been taking a deep dive into specific policies and issues in the system. So I think it's helpful to sort of step back a bit. So first of all, immigration detainees are held on administrative grounds, not criminal grounds. And immigration detention is not a form of punishment. Because immigration detention is an administrative ground, however, immigration detainees are not afforded the criminal justice safeguards that have been developed over centuries. Although immigration detainees may very well experience their detention as punishment, because after all, they're deprived of their liberty and sometimes they're detained in jails alongside criminally accused and convicted individuals, they're not accorded the protections that would be there if they were actually being punished. Immigration detainees are generally detained for reasons completely unrelated to public safety concerns. And some statistics here I think are helpful. So in 2017 to 18, 95% of detainees were held because the government suspected that they were a flight risk, they had an unclear identity, or for the purpose of completing an examination. And despite the fact that the majority of immigration detainees are not detained for grounds related to public safety concerns, last year nearly a third of detainees were held in correctional facilities, rather than the Immigration Holding Centre. And of the immigration detainees held in Ontario jails, more than 80% were held for reasons, again, unrelated to public safety concerns. There's no limit to the length of time immigration detainees can be held, and many are held for months or even years. The longest instance of detention in Canada is 11 years. Canada remains one of the few countries in the world that doesn't have a legislated maximum length of detention, and this is the source of a lot of the mental health issues that we see among immigration detainees, because they just don't have a sense of when they will get control back over their lives. And finally, deterioration of mental health is incredibly common in immigration detention. Almost everyone who experiences detention develops some kind of mental health issues. I'm happy to say that in recent months, we've seen some positive policy developments and important initiatives in this area, many of which were in response to this audit, and it's great to hear that we'll have a new guideline coming out. And I think it's important to give credit where credit is due, and these are crucial first steps in the right direction. Unfortunately, these policies and initiatives are not the ultimate solution, and they may very well amount to safeguards written in pencil, because the laws and regulations remain the same. These policy safeguards fail to measure up to the robust legislative, regulatory, and structural protections necessary to remedy and prevent human rights violations that take place in this system. And all the stories of the immigration detainees behind me can still happen under the law as it currently stands, because the authorities simply have an incredible amount of discretion when it comes to depriving the liberty of non-citizens. The serious gaps in the immigration detention system become even clearer when these policy safeguards are compared with the protections available in other areas of the law where deprivation of liberty is on the line, such as the criminal justice system. And we've seen that when a system grants authorities a great deal of power and discretion without adequate safeguards to make sure that that power and discretion are used appropriately, the results can be devastating and even deadly. So the audit provided us with another opportunity to engage in advocacy and take up issues that are at the heart of the immigration detention system. And as David mentioned, our upcoming report is a coordinated response from legal professionals and experts working on behalf of immigration detainees across Canada. And the analysis will focus on issues of procedural fairness. Because the report is still being finalized as we speak, I can't get into too many details about the final recommendations, And of course, they will also depend on what we find in the guidelines. But I'll just briefly discuss 3 major issues that the report will analyze. So these are issues of independence, evidence testing, and discretion. And all 3 of these issues could be traced back to the fact that under the law, adjudicators are not bound by any legal or technical rules of evidence and may base their decisions on evidence adduced in proceedings that they consider to be credible or trustworthy in the circumstances. So essentially, people could be deprived of their liberty through proceedings that are not bound by rules of evidence. And for those of you who took evidence law in law school, can understand the gravity of that statement. One lawyer that I interviewed for this report noted that this standard aggravates issues of independence between the Immigration Division and CBSA because the issue is not simply what the audit called an overfamiliarity between adjudicators and officers. It's a matter of trust. It's an issue of Immigration Division adjudicators trusting that the CBSA officer before them is putting forth evidence that is true, credible, and trustworthy. Another lawyer interviewed noted that there's an automatic default assumption that all CBSA evidence is credible and trustworthy, even when there's nothing to back that up. And of course, issues of independence are also aggravated by CBSA officers' failure to fulfill their roles as officers of the court. They're mandated to argue for continued detention for the purpose of deportation, and this often flies in the face of fairly presenting the full scope of evidence available in a given case, including exculpatory evidence. According to one lawyer I interviewed, CBSA hearings officers see detention as a win, and there's a degree of good faith that just isn't there. And again, unlike every other major law enforcement agency in Canada, CBSA remains the only one without civilian oversight. In the absence of meaningful disclosure of evidence from CBSA, detainees are often left to challenge CBSA's hearsay evidence. And according to several lawyers I interviewed, Immigration Division adjudicators rely on hearsay evidence from CBSA to make decisions in every single case. Finally, the law provides a great deal of discretion for authorities to impose detention, but several lawyers indicated that adjudicators do not engage in substantive analysis. Instead, they use more of a checklist approach that can essentially land detainees in a catch-22. So, for example, one lawyer observed that flight risk could constitute any hint of fearing return to your country of nationality. So for asylum seekers who by definition fear returning to their country of nationality, they're essentially faced with the options of detention in Canada or persecution back home. And the difficulty is that given this wide discretion to deprive liberty, there's a lot of space for institutional culture to drive decisions. And what we've found is that the enforcement culture is prominent across the Immigration Division and CBSA, so that adjudicators and officers often fail to appreciate the gravity of what it means to take away somebody's liberty. And I don't believe that this is something we can fix with training or even policy guidelines, which are of course not legally binding. In a recent paper that from Jared Will, Josh Bloom, and Sienna Antis, they observed that as it stands, the power to detain non-citizens is broader and the protections afforded to non-citizens are fewer than under any other legal regime known to Canadian law. The gravity of taking away somebody's liberty simply requires more robust legal safeguards, and that's the issue that I hope we could ultimately address. And I'll leave it there because I know we have a lot of questions.
Great, thank you very much, Hannah. I appreciate it. It really shows that we all have a role to play in creating a system that is just and fair. What I would like to do now is to take questions from the audience. If you do have a comment that you would like to make, I'd ask you to make it rather brief so that we can get as many people's inputs as possible. I'll take 4 questions at a time, and please, if you do have a question for a specific panelist, please address it to them. Yes?
A very brief comment and question. What I've been hearing, the big issue is an issue of allocation of resources. Because in an ideal type of situation, they would not be sequestered, say, in a in a criminal type of institution, a jail, let's say a form of community college, with trainings, education, programs, living with family, decent food, and all that, and we deal with the politics. And the whole element is that so much of the information are considered to be felt imperatives. As the comment was made by one of the speakers, the lack of evidentiary material in terms of support. And the only anecdote I'm going to share, I was placed in somewhat of a similar situation when I'm a governance advisor at UNDP. But in Goma, in eastern DRC, about 4 or 5 years ago, there was a great surge of refugees for reasons external. And since I could read and write and could walk, I was requested to participate in an adjudicating type of panel. And you have literally life and death type of situations. And how do you decide? In a sense, because the comment made, active, passionate adjudication. It takes so much out of the individual. How do you control yourself? How do you keep yourself dispassionate and objective to all this? And in Canada, we're dealing with the realities of politics. And I'm sure that's a form of overriding imprimatur. How do you deal with this? And in terms of the audit, starts to ask the questions, but you also keep banging against the reality of politics, of those people that want to be re-elected in terms of short term. So how do you engage in a manner prescriptive?
Are there any other questions? Yes.
Okay, I'm just going to bang through a couple of quick comments quickly and also some fodder for discussion. So one, I just want to say, I think probably on behalf of most of the people here, to Ms. Laird, thank you for that extraordinary document. I think it's a historic piece of work that will have resonances in decades and generations to come. It's totally shifted the discourse, as you can see even here. But as a practitioner in the field and as a human being, it was probably one of the most affirming and powerful pieces of writing that I've ever read. So thank you for that. So to Aviva and to Nancy, one piece just on this issue of duty counsel, we had a picture up from Hannah's presentation of Teresa Grattan. It's a matter of public record that Teresa Grattan was in detention, and she was in detention having lost her status from having a conditional sentence. She lost her PR status and was detained, having been, having been sort of pushed into the to the immigration admissibility framework. Well, and while she was there, the Supreme Court issued the Tran decision, which changed her entire situation so that she was no longer inadmissible, and she was in fact, she continued to be a permanent resident. With a simple application, with a simple application that someone, a duty counsel or someone would have been able to intervene, get it sorted out, and she could have been released from detention. Instead, she died in jail, right? So if you want an example in practical terms of the absolute imperative of getting duty counsel out there, her story and her legacy is one where the Immigration Division, Legal Aid Ontario, the Government of Ontario, has to see that case and say, that's it, we have to fund duty counsel, it has to be robust, it has to be at all of the institutions permanently. And the one thing, and I think I'd be very interested to hear from other practitioners in the room here, is about this ongoing question of whether or not bondspeople are in fact being interviewed by the members, right? We still have detention reviews being conducted inside maximum security ranges in prisons with unrepresented detainees, where the family members are being interviewed in hallways and in prison rooms, and then the evidence is being summarized and reported by the CBSA officer, adverse in interest to the person's release, and this is going on, right? I had this happening in cases before, during, and after the audit. It's a huge problem. And then finally to Sarah's piece, and I'll be done. I have also had people who have been ordered released by the Immigration Division, and then when their families went to the CBSA front desk, a clerk told them no. A clerk told them the copies of the T4s that you gave us are too blurry, we can't see it. So I wrote Ralph Goodale, and I have a letter from Ralph Goodale outlining his theory on how the CBSA has an ongoing duty to evaluate the solvency of proposed bondspersons. So maybe we can work on that.
Any other questions?
Should I just speak out loud?
Sure. You can start speaking solo.
Okay. So, I was formerly a member of the Ontario Parole Board, and I know it's a different system. It's a criminal system, and these people are convicted of offenses, so they're seeking to be released early from a sentence. But the issue is similar with the immigration matter in that you're depriving someone of their liberty that could be released perhaps on grounds earlier. And the whole system in the parole system is based upon professionals, social workers, psychiatrists, who make the assessment of risk, make the assessment of flight risk, who make these assessments on a professional capacity. And these professionals obviously have bodies that provide oversight of them, so that they're, without the CBSA having any oversight, at least the people who are inputting decisions, dealing with flight risk in the parole system, dealing with risk to society, they are professionals who have a large role to play in determining whether someone will be released early. So I think that this whole model needs to be looked at within the immigration setting, where other professionals can be incorporated into the system and where their assessments can have some further weight.
Is there one more question or comment?
One of the challenges that I'm still seeing, and I'm understanding that there's recently been training for board members with respect to mental health, I still have yet to see a real change when it comes to individuals with severe mental health issues. And for example, someone whom for months there's undiagnosed mental health issues, and then we get a psych report, and now the same mental health issues are being used against this person, and further in this finding of danger to the public. So I think that's certainly one of the challenges, and I'm wondering what can be done to find options of treatment. It doesn't make much sense, but I'm trying to have someone transferred to a psychiatric facility in St. Lawrence, and it is a bureaucratic nightmare. No one really wants to get it done. There's also issues between St. Lawrence and CBSA. So I'm wondering if there is anything that can be done to sort of encourage this option for individuals with severe mental health issues who are not to the point where they are completely out of control, but where they have issues that are severe enough.
Okay, well, I think we have about 10 minutes left, so those are mainly general questions. I'll give each panelist an opportunity, perhaps 3 minutes or so, just to respond to those, and then we can wrap up. Kathy, would you like to go first?
Well, I guess I could respond on a couple of points. In my remarks today, I didn't talk about the problems around mental health, but that every detainee that was held for a lengthy period of time had some mental health issues happening. Maybe they preceded the detention, but always by the time I was listening to their hearings, the problem had gotten worse. And we did see a situation where, well, more than one situation in which stereotypes about people living with mental health issues came into play. The assumption was that they were dangerous. So that I found, very disturbing. And in 2 cases, the federal court got involved, ordering CBSA to obtain psychiatric assessments in order that the information that the ID needed to make release would be available. So sort of speaking to your point, we need an expert assessment of what this person needs and what supports they would need in order to be released. It did seem like it was a bureaucratic nightmare. One person was transferred into St. Lawrence. Yeah. So I think that's a very real problem and one that is probably difficult to tackle. In that case, they got the public trustee involved, and I wondered why that didn't happen sooner. And speaking of the, what are they called, the designated representatives, in one case, the designated representative was useless at helping to bring together the resources, and in another case, they were very effective. I'm not sure if this, I just wrote down a note about how the sort of petty criminal offenses that led to detention for years, how differently those same offenses were treated in the criminal system. So, that was something I noticed throughout the cases, and it's something I did mention in the report. We haven't talked at all about the Toronto bail program, but what I found is that if the Toronto bail program refused a release, then that person never got released, even if community resources were brought to bear that looked very similar to what the Toronto bail program could have offered. And within the idea, there was an awareness that people who would be released in other regions were not being released in Central Region because if the bail program didn't take them, then they weren't going to get released. So, obviously there's some good things about having the Toronto bail program there, but it also did seem to create this problem. So I just wanted to touch on that because I haven't mentioned it before. And it also ties in a little bit to the danger of perception bias, right? Because CBSA funds the bail program's availability, as I understand. It was impossible to find anything about the bail program, how it started, who funded it, why it even existed. But in the end, I think it's CBSA that's funding it, so that's one of the parties, right? So, yeah.
Eva, 2 minutes if possible.
I guess if there's one thing that I want to leave everyone here with is a genuine invitation to let us know when there are concerns that happen in specific cases. So Sarah, you've raised a few incredibly troubling issues. The idea that CBSA might be suggesting a higher or requiring a higher bond than that was ordered by the Immigration Division. I haven't heard of that happening. If that happens, I would invite you to let us know with specific reference to a case. If you see, there's a policy that members and CBSA officers are not meant to be sitting there chatting. If you see that, it's much more helpful to get that information. It's really, unfortunately, there's not a lot I can do with, it's already a policy, so how do I act on it when it happens? I need to know about it when it happens with reference to a specific case so that I can look at that, who was the member, what was happening, and take some action if action is required. I agree on the issue of duty counsel. I don't have any control over whether legal aid creates a duty counsel program, but hopefully Simon sitting right next to you can get one started, or Amanda right behind there, who both work at Arlo. It is crucial. I agree 100%. So the detention reviews that I have witnessed, I've gone in to see. I haven't seen CBSA doing interviews outside and coming in and summarizing it. I have seen the ongoing, absolutely concerning bifurcation of the process where it's still happening on the record, but the member and CBSA and the hearings office and the counsel go out to examine the bondsperson, and then it's the member, in the ones that I've seen, that summarize what happened in the detention review. That is still not a fully fair hearing. The detainee, the person concerned, needs to be present during the examination of the bondsperson. I agree, and it's something that we are aware of and working on. I think I'll leave it there for now, but really, if there are concerns, let me know. Tell me the case name, tell me the date that it happened, and we'll look into it.
I see 2 minutes, 3 at most.
Okay, actually, I wanted to just quickly respond to something very important that Sarah mentioned. She said, tell council to the ID, tell council what you want to see when there's a proposal being offered. And I think that's really important because it has to be interactive. And I think that 3.1.4, the new guideline, I hope will address this, and certainly in practice it would. Where a member determines an ATD, alternative detention, is necessary, may be appropriate, each element has to be weighed to determine overall adequacy. A member should always articulate any concerns with a proposed alternative to detention, give an opportunity to both parties to respond, including calling witnesses where appropriate, prior to rendering a decision. And so if an alternative is proposed, whatever it is, and if the member has concerns that it won't address whatever their concerns are, that prior to rendering a decision, they're supposed to advise the parties what those concerns are. So hopefully that would address that concern. On the point with respect to the parole board and indicating that the parole board has professionals who can explain what the danger is, what the flight risk is. There is a part in the new guideline, something similar existed in the old one, but basically this one I think is more pointed. When considering release from immigration detention for a person who has been released by the parole board, members must take into consideration the conditions that have been imposed on the person concerned and the additional supervision that will be afforded by correctional service. But that addresses a specific concern in a specific case. But I think it is an interesting notion of that there are these professionals who advise the parole board with respect to potential flight risk and danger. So it's certainly something to consider and look at. On the issue of when the ID releases, and I think it's been mentioned a few times today, the ID orders release, but because CBSA still has to make an assessment of the bonds person, that sometimes what occurs is that the person is actually not released, which seems to be a frustration of the release ordered by the ID, and it's certainly not something that is intended by the ID. Perhaps, given the notion of active adjudication in the new guideline, and the emphasis on active adjudication is that perhaps one way of ensuring that does not happen or happens less, just within the confines of what we have in the legislation we have, is to have members question more the bond person to ensure. I mean, we see and we know, based on the regulations, what the concerns are and what they're supposed to be looking at, especially in terms of solvency. And of course, that's sort of an overlapping of questions by the ID at a detention review, and of course, following the detention review by CBSA. But if the member is asking more questions with respect to the solvency of the bonds person, because clearly, if the member is ordering release with respect to a certain amount of the performance bond, then the member wants to ensure that that bond is going to be able to be met as well. And certainly if the member's ordering release, their expectation is that the person is actually going to be released.
Thank you very much. Anna, do you have any comments?
Sure, I'll keep it quick because I see we're running out of time. But I just wanted to address the issue about the politics of this whole system. And of course, the politics can be very difficult, and the politics of non-citizens is becoming more and more difficult around the world, and that's a reality we have to deal with. But I think if you get close enough to some of these stories to appreciate the details and really see the injustices, it doesn't have to be a difficult political question. And I think that's one of the things that made Kathy's report so powerful, is that there's so many there's so many detailed examples of real stories where it just became really obvious what the injustice was. And so I think if you boil it down to an issue of, how much do we value human rights? How much do we value liberty and trust? I think, that's a good way to address the politics. And stats are, of course, also really helpful to sort of get a big picture perspective and understand that we're not talking about danger here. Like that's not really an issue. So, I mean, it's not the issue that we're talking about. So I think that's one way to address the politics of it.
Thank you, Sarah.
I definitely agree with Hannah that a good way to address the politics issue is actual evidence, and to have this be an evidence-based process. I have never, in either the security certificate or the detention review regimes, I have never heard CBSA even attempt to justify why they wanted a particular condition imposed. It's always like, well, the minister would be more comfortable with this. I don't particularly care what the minister is more comfortable with. Why do you think that will actually change flight risk? Why is it more important to have a person report once a week to GTAC when they live on the other side of Toronto and don't have a car in person? Why can't they report once a week by phone? Can you actually tell me, show me that that makes a difference? And I mean, this is really something that, that I think perhaps academia needs to pick up on, because we're all run off our feet with the advocacy stuff. But to be able to say, look, this is a condition that does lower flight risk, and this is a condition that doesn't, so why bother burdening the person with it just so you can have, my detainee got 10 conditions and yours only got 9, so I win. And I think it would also, help us craft tailored alternatives to detention if we knew what evidence there was that particular conditions actually addressed particular situations and in what context. In terms of the CBSA members and the division members having close relationships, look, I understand that there are, however many members and a certain number of CBSA officers, and they see each other all the time, and I don't necessarily think that it is a problem if 2 of them are chatting about their weekend, in an isolated incident. But I think that it looks so terrible and it is such a slippery slope that the Immigration Division really needs to go out of its way to avoid that. And I think one of the easiest way to do it would be to have CBSA ejected from the hearing room between hearings and go back in only when counsel goes back in. Like it's, and if it's at Maplehurst or whatever, the member can go in first, cool, the interpreter, whatever, I don't care. But CBSA goes in with me and we stand there at the metal detector taking staples out together. Because we are, we have equality of arms, and that means that we're subjected to equal bureaucratic nonsense as well as any preferential treatment.
Couldn't the member go in and out? That might even be easier.
Well, no, because the other thing is you walk in and the CBSA officer is set up with their laptop and all their stuff.
But what if the member's not there? So the member only goes in when both of you are set up. That's what most tribunals do.
It is. There are extraordinarily irritating logistical and security issues associated with adjudicating in the jails.
Yeah.
And not to say that what your comments are not absolutely appreciated. It's the one thing that if I've learned anything over the past few months, it's how quite logistically complicated. The barriers to fair hearings are not only an adjudicative culture change. But we have to take that stuff absolutely seriously as well. It's a little bit easier to implement those policies at the IHC, where it's my understanding that CBSA officers and the ones that I've witnessed do leave the hearing room in between hearings. It may not be, it may be only happening when I'm there, so to be reviewing the video or something and hearing your comments, but of course.
Well, and just a final comment regarding the mysterious CBSA release wizard. I learned that CBSA has this list that is much longer than anything the Immigration Division has ever published of documents that are required. And whenever I'm up there, I look at the list and I take an extra copy, or I take a copy with my phone, and the next bond or the next detained person or detention review I do, I give that to the bonds people and I say, look, this is what you're going to need. And I make it a practice, and I am usually successful in extracting from the bonds people an affidavit, and I'm going to put an anonymous template up on the resources site for you guys, as well as a list of, you will be bringing these documents to Rexdale. So what is incredibly frustrating is when you have a person put into evidence 3 months of T4s, a letter from their employer, 3 months of bank statements, proof of citizenship, all of the things that CBSA claims they're going to require. And then a CBSA hearings officer and you and a member, the three of you all agree this person is okay, this bond amount is appropriate, and then some mysterious stranger says no. So like I said, if CBSA in processing the bond found that there was some new information that perhaps the member hadn't considered, there might be some wiggle room there for CBSA to have some ability to suggest that the order was made on false pretenses or incomplete information. But when all of that information has been presented, when I literally take my DR2 package over to the window and hand it to the person, and they say no, that's in contravention of the law. And yet it happens, and it happens not all the time and not infrequently. I think we need to know who that person is. I think we need to know, and I don't mean the actual person, but like the officer. They need to be, and it needs to be made very clear and explicit and public what power they do or do not have. And I think the ID really needs to push back against the idea that anyone but the member can change the terms of a release order. And unfortunately, the way they do it, like I said, is they kind of make the family choose, do you come up with another $2,000 or do you wait a week to get your husband back? So it's not enough to complain after the fact to the Immigration Division. The Immigration Division, and like I said, we've always tried, we go back into the, we go into the other little window room and say, oh my God, this is happening, and we get shrugs. Well, unfortunately, all the members have gone home, so they're gonna have to decide what to do. The member needs to stay there, or a member needs to stay there to say no, basically. If the CBSA isn't gonna follow the law, then the Immigration Division needs to enforce its own jurisdiction.
And so I'll give you one opportunity.
Just one thing I just wanted to mention. One thing that I did mention earlier, and that is in the new guideline, which is something that I think is very important that it's stated in a few places, and the thing that council has to ask itself, and certainly will be trained members, is the very first question isn't how much is the amount of bond. The very first question is a bond person necessary? And I think that's really important, and that's something that you as council before the ID want to stress before the ID, and also that's very much the theme in one of the major themes in the guideline as well. It's this notion of a ladder principle and the least amount of restriction against liberty as possible. So that's the very first question. So obviously if there is not a bonds person, that's less of a concern. So that's the very first step, I think.
Thank you very much. I'd like to thank all of our panelists. I saw copious notes being taken, which I think is a good indication that this will be an ongoing dialogue. We will be taking 15 minutes for a break, so returning at 11:20, 11:25. Again, I'd like to thank all of our panelists. Thank you very much for your contributions. And